And Mr. West.
Morning, Mr. Shima.
The second case for the 1:30 p.m. docket is appeal number 122332 in the matter of Amy J. Ahrens, original action and attorney discipline. The disciplinary administrator has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Would you please state your appearances?
May it please the court, Your Honors, Gary West appears on behalf of the Office of the Disciplinary Administrator.
Okay, please the court. The respondent appears in person by John Ambrosio. We are ready for argument.
Thank you, counsel. Mr. West, you may proceed with your argument.
Thank you, Your Honors. The hearing panel found that the respondent, in 3 separate interviews to 3 different law enforcement officers, lied about her knowledge regarding her then boyfriend's involvement in selling drugs. The first 2 occurred in July of 2016 after a traffic stop. The traffic stop resulted in the seizure of $22,000 in cash and 58 grams of marijuana. The third interview occurred 2 months later in Topeka, where the respondent continued with the same lie until the detective confronted the respondent with evidence of the truth that the respondent had been present during her then boyfriend selling drugs. At that time, the respondent came clean. The respondent was charged out of Lincoln County, Kansas, with possession with intent to distribute a level 3 drug felony. A level 3 drug felony, regardless of a person's criminal history score, would land them in a presumptive prison box on the sentencing guidelines. The respondent cooperated with law enforcement in the investigation of her then boyfriend. The case out of Lincoln County was dismissed. The hearing panel concluded that the actions of the respondent violated Kansas Rules of Professional Conduct 8.4 C, D, and G. The other violations found by the hearing panel resulted from a separate case. In that case, the investigation concluded there was a lack of probable cause to support the complaint. However, the respondent failed to reply to any communications from the Office of the Disciplinary Administrator and failed to cooperate in the investigation. The hearing panel concluded that these actions resulted in a violation of KRPC 8.1 and Supreme Court Rule 207. No exceptions were taken from these findings. The actions of the respondent violated her duty to her profession, to the judicial system, and to the public at large. As officers of the court, lawyers must abide by the rules that shape the administration of justice. One such basic rule is that all citizens must be honest when answering questions posed by law enforcement. Thus, by lying to law enforcement, the respondent breached a basic duty to the administration of justice. By failing to reply to the Office of the Disciplinary Administrator or to cooperate in the investigation of the second complaint, the respondent violated her duty owed to the profession. And by lying to law enforcement, she violated her duty to the public by failing to maintain her personal integrity. The mental state in which the respondent acted when committing these acts was knowingly. The respondent, by lying to law enforcement, acted with a conscious awareness of the untruthfulness of her statements and the attendant circumstances. Thus, the respondent acted knowingly. Injury did occur. By lying to the law enforcement, respondent caused injury to not only our profession, her profession, to the legal system, and to the public at large. These were the duties violated. There were aggravating circumstances and several mitigating factors. The aggravating factors are that the respondent acted with dishonest and selfish motive when repeatedly lying to law enforcement. She did this in an effort to avoid getting in trouble. This reflects poor judgment and a lack of credibility. The respondent obstructed the disciplinary process when failing to reply or engage in the investigation. This would be an aggravating circumstance. And The respondent's use of controlled substance would also be an aggravating circumstance as well as a mitigating circumstance. The mitigating factors are that the respondent has no prior disciplinary history. The respondent had personal and emotional problems that she was facing. The respondent's most ardent supporter and confidant had been her mother. Her mother had passed away from cancer while she was in law school. The respondent at the time of these actions was suffering from depression and anxiety. The psychotherapist in her report indicated that the respondent was both dependent and scared of her then boyfriend, which could provide some explanation as to why she found herself in that circumstances and could not extract herself from those circumstances. The respondent was a new lawyer. She had only been practicing between 3 and 4 years. This would be a mitigating circumstances. However, in spite of the fact that she'd only been practicing for 3 to 4 years, she had developed a very good reputation within the Leavenworth County Bar. They describe her as bright and capable attorney, an attorney who was prepared, and an attorney who was well liked within the bar. And at the hearing in this matter, the respondent expressed genuine remorse and has taken steps to improve herself. The ABA standard, which applies to the actions of the respondent in this matter, which is applicable to her actions, is ABA standard 5.12. This standard states that suspension is generally appropriate when a lawyer knowingly engages in criminal conduct that adversely reflects on the lawyer's fitness to practice. The respondent's actions in this matter fall squarely into this standard. The hearing panel recommended an indefinite suspension. That is also the recommendation of the disciplinary administrator, and that would be our recommendation today. Thank you very much.
And Mr. Wesley, is the disciplinary administrator still stand for the position that the suspension should not be made retroactive?
Well, I would say in response to that, that I would, in rebuttal, I might have an opinion regarding that. I always want to wait and see what Mr. Ambrosio presented, what has happened in the time period since the panel hearing. I would state if things have continued like I suspect they have continued, our office wouldn't object to the suspension running from the panel hearing. I suspect Mr. Ambrosio wants it to run further back. I didn't state that the respondent's license was administratively suspended back in 2017.
All right. We'll let you address my question in rebuttal then.
Thank you, Your Honor.
Are there other questions? Mr. Ambrosio?
Thank you. Madam Chief Justice, Your Honors, may it please the court. And my client would like to address you at the conclusion of my talk in regard to this matter. At the outset, let me say that there is no doubt that the facts described in the panel report and the conclusions of law were dead on and accurate. We understand the recommendation of the panel and their indication of what disciplinary rules were violated. We understand and agree that she should be suspended. The question is, how long should that suspension be? We understand it should be indefinite. We agree with that because she's working on her program. However, we believe it should be retroactive back to October 31st, 2017, when she was administratively suspended because she didn't do CLE, she didn't pay her fees, etc. This has been a work in progress for this young woman who is bright, she is smart, and she has a good future. The question probably all of you are asking is, how do bright, smart, educated people get in this situation? And I think I'm not smart enough to understand why PTSD hits. I'm not smart enough to understand a lot about psychological background, but it was described in the panel report on page 18 in paragraph B. Dr. Higginbottom, who testified in this case from Denver, she is the therapist now involved with my client, indicates that she is not currently, at that time, ready or fit to practice, that she wouldn't be ready for about 18 months, and only if she worked to a program, dealt with therapy, stayed off drug and alcohol, and continued to work her program. What my client wants to do is she knows she's going to have a hearing once she's suspended. She's going to have a hearing to determine if she is ready to come back into the practice, and we'll have to present the evidence that will show that she has worked her program. Then, if she gets her license back here at some later time, she then wants to work and practice in Colorado, which she currently lives with the father of her child and her 2 kids. She has been working through 2 pregnancies. She continued in therapy. COVID stopped it a little bit, and the cesarean section led her to be bedridden for quite some time. She's ready to start practicing again as far as meeting with her therapist. She is working at a sales position. She is working hard to support her family while the gentleman she's with acts as a house husband. She lives in Colorado. She'll continue to go to therapy. She wants to work with KLAP, and she also is starting to work with the same group that is in Colorado, as far as having a mentor, as far as having somebody work with her as she gets through the problems she's had with drug abuse and the problems that are described in paragraph 14. This is a young woman who needs a chance again. She will admit to you, as she did to the panel and to Mr. West, that she made major mistakes. She got involved with an individual who told her what to do, abused her, and she was afraid of him. I understand that that's not always an excuse, but it was bad for her to do so. She allowed him and attended on 3 occasions where he sold marijuana, and she should have known better than that. And maybe she should have run. But it is my understanding from talking to Dr. Higginbottom and other psychologists and psychiatrists, sometimes it's difficult for a woman, or maybe a man for that matter, to get out of those relationships. Once she was stopped on her way back from Colorado with this gentleman, she realized how bad the situation was. She panicked. And Mr. West is absolutely correct. She panicked. She lied to law enforcement. Maybe what she should have just done was fived up, and this would have ended, and then she could have gotten a lawyer and dealt with those problems. She chose not to do that because of what is described in paragraph B on page 14. She is on her way to recovery. She's not using. She is living with her family. She's doing everything possible to change her life. She will work with Dr. Higginbottom until Dr. Higginbottom indicates that she is ready to practice. So what we're asking for is that it be retroactive, at least to the hearing, and maybe even further than that since she hasn't been practicing. That's all that I have at this time. With the court's permission, my client, Your Honor, would like to address the court.
First, are there any questions for Mr. Ambrosio?
I have a question about dates. Both parties are suggesting indefinite suspension. You have asked that it begin from the date of the administrative suspension in October of 2017.
That is correct, Your Honor.
It would appear from at least some objective appearances that the downward spiral that your client was in was continuing at that time. When would you say that she seriously and unequivocally turned things around in an alternative to that date?
I don't want to pat myself on the back, but I believe this when I got involved, which would have been, according to the panel hearing, sometime in June 2 years ago. I believe I'm correct on that. Not that I'm patting myself on the back, but then she got involved with Dr. Higginbottom. She got into KLAP at the time when I got involved. And the panel indicated when I get involved, but I don't see it in my notes. I trust I've answered your question. And then the spiral, she leveled out at that point, and she's been working, Your Honor, on this since that time.
Other questions? Ms. Ahrens, if you would like to address the court, you're certainly welcome to. You still are on mute, though.
Thank you.
Sure. We do that all the time.
Good afternoon. Thank you for taking the time to hear my case and allowing me this opportunity to speak in front of you all. I know that I'm responsible for my past mistakes, and it is those mistakes which bring us to these proceedings today, and for that, I'm truly sorry. I passed the bar at the end of 2012 and began my own law practice in Leavenworth, Kansas shortly thereafter. By 2014, at the age of 27, I had a well-established general practice law firm where I focused on criminal defense and family matters. I was young and had already achieved my lifelong dream of becoming a criminal defense attorney. My family and peers had all expressed pride in my success, and it became especially important to me to maintain this impression, even to the point of my own detriment. Unbeknownst to most of my peers, I was battling heavy depression through law school and early on in my professional career. This was brought on by primarily two factors in my life. The early death of my mother while in law school, and the subsequent isolation felt while completing school in Kansas after her passing, far away from friends and family back home in Colorado. These factors, coupled with the detrimental desire to maintain a perfect appearance with my family and peers, led me to make some bad decisions. In early 2016, the romantic relationship I was involved in had driven me from maintaining relationships with all but a few fellow attorneys during my workdays. I had cut much of my support structure out, and I became increasingly reliant upon my partner to replace friends and family, an obvious mistake looking back, but not so apparent at the time. By June 2016, I realized that I needed out of the relationship I was in, and I needed to move back home to Colorado to be home with family and friends who could support me. The truth was that I had been involved with someone whom I suspected was breaking the law, but I couldn't find myself to leave him. I was so scared and isolated and maybe a little too proud to seek help. It was foolish. Shutting others out helped make it easier for me to rationalize my relationship. Additionally, the less my family and friends knew, the easier it was for me to maintain my image of success that I believed was so important for me to maintain with them. I had too much pride to realize I needed to ask for help, and also scared that ending the relationship would expose my failings. I look back on that time with so much regret. Had those years in law school away from my family and my mother been for nothing? In the years since my arrest, I have been filled with so much anxiety over having indeed ruined my career before it ever even really had a chance to begin. I do thank God every day for my arrest, however. It has given me a new beginning. Do not misunderstand, the arrest was not my turnaround point, but merely a speed bump to the road to rock bottom, and I've spent the last 4 years climbing out. I moved back to Colorado in 2016 and lived with my dad and stepmother, who have been instrumental in supporting me. They gave me a place to live while I battled my issues. Upon first moving back, I was still in a dark place. I didn't know what was going to happen, and everything that I had worked for my entire life felt like it was slipping through my fingers at a moment's notice. I didn't know how to get in control of anything. I didn't know where to start, and part of me didn't even know if I cared enough to even try. At one point, I was living couch to couch and just hoping that I would have somewhere to stay that night. I had finally started a job in sales at a company near Denver that gave me an even greater sense of family. Day by day, I felt myself slowly coming to life again. I became involved with a much kinder and supportive gentleman named Jay. He became my confidant, and we worked equally in the relationship to support each other and ourselves. I became pregnant with our first child, Lonnie, who was born in May 2019. It was at that time that my first disciplinary hearing was scheduled. And up until then, I had been putting all my disciplinary issues to the side, because even at that point, the thought of losing my career was so unimaginable to me. It was too overwhelming to handle, so I just didn't. Not until my son was born, which lit a spark in me and gave me the strength and motivation to tackle my past mistakes directly. I contacted Mr. Ambrosio a week after I got out of the hospital from delivering my son and asked him to take my case on such short notice. That same week, I was back in therapy and was talking about my past transgressions for the first time since telling my family in 2016 why I was no longer practicing law. Therapy is something I know is crucial for me. It is a safe place where I can process my emotions and stay focused on my mental health. I have reestablished my relationships here with family in Colorado, especially my sister, all of whom have provided overwhelming support in the midst of all my mistakes. When all of this started, I was in my late 20s. I was a new attorney living in a new state with no family near. In fact, when I look back at those days, I don't even recognize that woman, as I feel like a completely different person today. I failed miserably by not reaching out for help sooner and leaving that relationship, and I fully accept responsibility for my situation. Today, I'm in my 30s with a husband and 2 children, a 1-year-old boy and a 6-week-old baby girl. I live for them, my family. All I want is to be the best role model to them and take charge of my past mistakes. I've never lost sight of the fact that what I risked and lost was huge and has put my future opportunities in jeopardy. It took some years and growing my own family to realize this. It is a privilege to practice law, and I believe that I will be an asset more now to our legal community. I appreciate the opportunity to speak before you today and beg for the court's mercy to be able to practice law in the near future so that I may excel in a career that I am so deeply passionate about. Thank you.
To answer Justice Wilson's question, recovery started, I believe, July of 2019. I'm sorry for interrupting.
And what is the, Mr. Ambrosio and Ms. Ahrens, you referred to a program that you're doing or engaged in. Can you describe that for me? And I appreciate you have a 6-week-old and that might be causing a little disruption in that, but tell me what you're doing.
I meet with Ms. Higginbotham. She's my therapist. And I meet with her once. Well, I had been meeting with her every other week.
Is there any other, Mr. Ambrosio mentioned KLAP, and then I know that there's a Colorado assistance program. Are you doing anything with them?
At this time, I've met with COLAP, and they're kind of on standby. They kind of wait for a recommendation from the court in order to get involved with their program from out of state, is my understanding.
Ms. Ahrens, when would you say yourself that you seriously started to turn things around with regard to your recovery and trying to get keep your license?
I would say that would be either May or June of 2019. It was around that time period. It was right after I had my son.
Other questions? Anything else from Mr. Ambrosio?
No, Your Honor, that's our submission. Thank you.
All right. Mr. West, you did reserve 3 minutes.
I don't think I need to use my 3 minutes, Your Honor. Mr. Ambrosio is correct about the time frame for when things started to change. Ms. Higginbotham's report covers the time period from July of 2019 to November of 2019. And in her report, she stated that she thought it would be 18 to 24 months before the respondent would be able to start limitedly practicing law again. That would be my only rebuttal. Thank you.
Any questions for counsel?
So that I'm clear, Mr. West, then you are suggesting that the indefinite suspension should begin when the Supreme Court makes its decision?
I think running the suspension from the date of the panel hearing would be appropriate.
Okay, and why do you believe that date is more appropriate than the date suggested by Mr. Ambrosio?
I think the conduct was extremely serious conduct. I'm confident that respondent is making strides to improve herself. I just think that that would be a more appropriate date than going back to July of 2019. The treatment report of Dr. Higginbottom covered a period ending in November of 2019. I think that date could be appropriate.
Mr. Ambrosio, why do you think the date of October of 2017, the date of the administrative suspension, is more appropriate in this case?
I think she started at that point to realize how bad things were. But I'm reconfiguring as I listen to the arguments of my counsel on the other side, and I listen to Amy, and I also reread everything that was in front of me. And maybe it would be smarter to start 2 years after that, or July 2019, when my client really turned the corner, although I hate to use that term, when she changed her lifestyle, when she stopped using drugs, when she was out of this area, and when she really started to work with KLAP and now COLAP. That's my rationale. It looks physical. I hope I've answered your question.
Yes, thank you.
Are there other questions? Thank you, all of you, for your arguments today. The court will take this matter under advisement. Court is now recessed.